Hello, and welcome back to Elise Explains IP, where we unpack the legal issues behind the headlines and explain what they actually mean for creators, businesses, and innovators. Today, I want to talk about a case that has been closely watched around the world. It's Getty Images and Stability AI, which was decided by the United Kingdom High Court last year in November. This was the first major decision anywhere in the world to seriously grapple with how copyright and trademark law applies to training and deploying generative AI models. While it's a UK case, it has real implications for Australia, both for rights holders and for AI developers. So, let's break down what happened, what the court decided, and then ask the key question: would an Australian court reach the same conclusions? So, the dispute in plain terms. At its core, this case was about who bears legal responsibility when AI is trained on copyrighted materials. On one side was Getty Images. It's a global licensor of professional photography whose business depends on tight licensing controls and strong brand recognition, including its well-known Getty and iStock watermarks. On the other side was Stability AI, the developer of Stable Diffusion, which is a generative image model trained on massive datasets scraped from the internet and released largely as an open source software. Getty alleged two main things in their case. Firstly, that Stability AI had used Getty's copyrighted images to train its model without permission, and that the model could generate images containing Getty's trademarks and watermarks, potentially misleading users. So, the copyright claim failed in the United Kingdom. This is where the case took a sharp and very important turn. Getty initially brought a primary copyright infringement claim, arguing that copying Getty images into the training dataset was itself unlawful. But Getty ultimately abandoned that claim, and here's the reason why. Because in order for it to be copyright infringement, it was accepted that the training and development of Stable Diffusion did not occur in the United Kingdom. And under UK copyright law and most laws, territoriality is critical. If the act of copying happened overseas, the UK court simply didn't have a domestic infringement to rule on. So the court never answered the question everybody wanted answered: does training an AI model on copyrighted images amount to infringement? Instead, the case pivoted to secondary infringement. Are AI models creating infringing copies? Getty argued that even if training happened overseas, the AI model itself, its weights, effectively contained Getty's images. On that basis, Getty said that making Stable Diffusion available for download in the UK and possessing or distributing it there amounted to importing infringing copies under the UK Copyright Designs and Patents Act. The court rejected that argument outright. The judge drew a clear distinction between a copy or a reproduction of a copyright work and a set of statistical parameters derived from analysing many images. The court held that model weights are not copies. They do not store, reproduce, or embody the visual expression of the original images in any recognisable form. As a result, Stable Diffusion was not an infringing copy, and making it available in the United Kingdom did not amount to secondary copyright infringement. This finding will no doubt be welcomed by AI developers, but it is also highly fact-specific and jurisdiction-dependent. Getty had more success on the trademark front. The court accepted evidence that earlier versions of Stable Diffusion, under realistic prompts, could generate images that included Getty or iStock watermarks. Using a trademark in the course of trade in a way that may confuse consumers can amount to trademark infringement, even if the use is accidental or unintentional. However, the court was very careful to limit its findings. The issue was historic, which was tied to earlier versions of the model. Filtering and guardrails had significantly reduced the risk over time, and therefore the infringement was limited and did not rise to reputational damage or any sort of unfair advantage. However, the message was clear: AI outputs matter, not just training inputs. So, what does this mean for Australia? So this is the really important part, well, at least for me anyway. Australia has different copyright legislation, but many of the underlying concepts are similar. I think you'll find in Australia we're going to have a very similar problem with the copyright law being territorial. If the training of an AI model occurs outside of Australia, which is probably 100% of it is, that will complicate, though not necessarily defeat, an infringement claim. Traditionally, Australian courts have taken a broader view of what constitutes a reproduction, particularly where temporary copies are made in digital processes. We do not yet have a clear judicial guidance on whether machine learning training involves reproduction in a material form. That issue remains open here in Australia. So, while the UK decision will be persuasive, it is not determinative in Australia. The other issue is the secondary infringement. Australia also has a secondary infringement provision, but again, the question would be whether an AI model is properly characterised as a copy of the underlying works. The UK court's reasoning that model weights are not expressive copies would likely carry weight here, but an Australian court would still need to be satisfied on the evidence and on the facts of the case. Let's look at the trademark issue and how that might be affected in Australia. Here, if an AI system generates outputs that contain registered trademarks or substantially similar ones and are used commercially, there's a real risk of infringement under Australian law. This aligns closely with the UK court's reasoning and reinforces a growing theme. Developers are increasingly responsible for outputs, not just inputs. So, what should you do next? For rights holders in Australia, monitor not just whether your content is used, but where the training occurs. Consider your trademarks and watermarks, and they remain a powerful enforcement tools. Think about contractual restrictions on AI training, because they're still your strongest protection. And for AI developers and deployers, do not assume that open source equals risk-free. Adding filtering, guardrails, and documentation, it can matter quite significantly. And be very clear about where training, hosting, and deployment take place. Getty versus Stability AI does not give us all the answers, but it does show us the direction courts are heading. Copyright law may struggle to stretch around AI training. Trademark law, however, is already proving far more adaptable. And in Australia, we are likely to see these issues tested sooner rather than later. Thanks for listening to Elise Explains IP. If you would like to discuss how AI affects your IP strategy or what might this mean for your business, please feel free to get in touch via my website, elisesteegstra.com.au. Thanks for spending time with me on Elise Explains IP. If you picked up something useful, hit follow, subscribe, leave us a review, or send it to a founder friend who could use this information. And remember, this is general information, not legal advice. If you do want help with your IP, you can book a strategy call with me at any time via my website. The link's in the description. So until next time, own your own ideas.